Good afternoon, sir. The council seeks permission to approach the honorable bench. The council seeks permission to approach the bench.
Yeah, please, sure.
Much obliged. The council seeks permission to collectively address the bench as your lordship.
Okay, please. Okay.
Your lordship, I am the counsel appearing on behalf of the petitioners in the matter of Govindadas and others and versus State of UP and others. I am the first counsel and I will be dealing with issue 1 and issue 2 and will take a time of 12 minutes. Please note that. And my co-counsel will be dealing with issue 3 and issue 4 and will be taking a time of 13 minutes and 5 minutes will be reserved for rebuttal.
Okay.
Your lordships, if you are well aware of the facts of this case, shall the council proceed to the issues?
Yeah, just tell me more about that. About the facts of.
Much obliged, your lordships. Your lordships, the case revolves around the Bange Bihariji temple in Vrindavan in Uttar Pradesh. It is a major Krishna temple.
Time has been started for the petitioners.
Your lordships, Bange Bihariji temple is a temple in Vrindavan in Uttar Pradesh. It's a major Krishna temple of the Pushti Mark tradition. It attracts over 50 million pilgrims annually, especially during festivals like Janmashtami, Holi, and Kartik Purnima. The temple lies within the heritage precinct of narrow lanes, traditional residences, religious institutions, and small businesses, causing congestion and complicating crowd management. On 19th August 2022, during Janmashtami Mangala Arati, a stampede led to 2 deaths and caused 25 injuries, attributed to overcrowding, poor entry and exit regulation, and inadequate infrastructure. And multiple PALs were filed in Allahabad High Court under Article 226 of the Constitution, seeking crowd management and safe entry and exit channels. The state of UP proposed the Bange Bihari project modeled on similar religious infrastructure initiatives involving demolition of 300 structures, acquisition of 8 acres of land, construction of corridors, holding areas, emergency exits, sanitation units, and medical centers. On 20th March 2023, the High Court of Allahabad, Allahabad mandated the state to implement the project, emphasizing public safety while balancing heritage concerns. Your Lordship, a writ petition has been filed by Govindadas, one of the residents and a practicing Sevadar in Vrindavan, citing that the displacement of 200 plus families, loss of livelihood for 500 businessmen, and there is a lack of public consultation in the project. And environmental concerns are also raised in the petition. Your Lordship, actually, it is approximately near 300 to 500 meters near to Yamuna River, and the risk of pollution, debris, and encroachment without an environmental impact assessment and statutory clearance has been mentioned in the petition. Also, the property rights issued under Article 300A were raised, alleging inadequate compensation, lack of hearing under the Right to Fair Compensation Act 2013, and also disputed ownership of some property. And your lordship, the state contended that over 300 crore had already been spent and delays would compromise safety, waste resources, and disrupt waste development.
Okay.
In 2020. And your lordship, the matter is referred to a 5-judge constitutional bench considering Article 14, 21, 25, 26, and 300A, your lordship. And a high-powered committee has been constituted to assess the issues, your lordship.
Yes.
Your lordship, this is all about the facts of the case. Shall the council proceed to the issues?
Yes, please carry on.
Much obliged, your lordship. The first issue is whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy or is a constitutionally valid exercise to remedy systemic failure endangering life and safety. Your lordships, may it please before this honorable court, the council would like to submit that the act of the High Court of Allahabad constitutes a judicial encroachment on the executive wisdom. The High Court, with reference to the fact, has mandated the project to the state of UP and they have directed to continue with the project. The court failed to assess the merits involved in the case. Actually, the state government has proposed the project and already spent 300 crores on such project without a public consultation and environment impact assessment. The court actually failed to assess these kind of risks involved in the project. Your Lordship, it is also submitted that the petitioners here represent displaced residents, shopkeepers, environmentalists, and heritage activists. The project involves clearing 8 acres of land, demolition of 500 plus shop establishments, 200 families, and 300 structures. Your Lordship, since it is a large corridor project, it needs clearance and it is required that the statutory complaints has to be conducted in a proper manner. Here, the act of the direction of the High Court actually overrides certain statutory requirements. It is not permissible to conduct to implement a corridor project without considering the constitutional issues as well as the environmental issues involved in the project. The grievances of the residents, shopkeepers, and environmental experts has not been heard, Your Lordship, by the High Court of Allahabad. So, Your Lordship, in Asif Hamid versus State of Jammu and Kashmir, it is held that while judicial review is the basic structure of the Constitution, the court must not intervene in the functions of the executive or the legislature. Your Lordship, the Council admits that Article 226 undoubtedly confers wide powers on the High Court to issue writs for the enforcement of fundamental rights and legal duties. But, however, this power is not unbridled. Its legitimate scope is to ensure that public authorities should act within the limits of the Constitution and statutory law and not to prescribe or dictate specific policy schemes. And Your Lordship, in Divisional Manager Aravalli Golf Club versus Chandrahan, 2008 1 SSCC 683, the court observed that judiciary cannot prescribe infrastructural projects. For doing so would amount to substituting judicial wisdom for executive expertise. By mandating the Bange Bihari corridor as the exclusive model for crowd management, the High Court displaced executive discretion vested under Article 162 and engaged in micromanagement that is beyond its constitutional limit. Your Lordship, that is all about the submission on behalf of the petitioners in the first issue.
Okay, that's all good. And what about the respondent?
Your Lordship, we have to discuss another issue also. The first issue is only completed. We have to move on to the next issue.
Yeah, please. Please,
Your Lordship,
continue, please.
Your Lordship, with due permission, the Council is moving on to the second issue, whether reconfiguration of temple approaches allies and religious circulation routes implicates Article 25 and 26. If so, the correct test to distinguish faithful facilitation from unconstitutional interference. Your Lordships, it is most respectfully submitted that the reconfiguration of temple approaches allies and religious circulation routes in the Bange Bihari precinct directly implicates the fundamental rights guaranteed under Article 25 and 26 of the Constitution. Far from being a neutral act of facilitation, the proposed corridor project interferes with the essential religious practices and undermines denomination autonomy, thereby amounting to unconstitutional interference. The material facts are crucial. The Bange Bihariji temple is not merely a religious monument, but a living center of worship. The surrounding alleys and pathways are organically evolved religious circulation used for rituals such as parikrama or circumambulation or pradakshina and processional worship. The state's proposal mandates demolition of over 300 structures and redesigning of these alleys into broader corridors. This would fundamentally alter how devotees approach the temple, the way they enter, exit, and move around the temple. These pradakshina routes have been interfered by the proposed corridor project, Your Lordship. It violates Article 25 guaranteed under the Constitution. This is what at stake is not only a physical space, but centuries-old ritual practices intrinsic to the Vaishnavic tradition. With a reference to the first paragraph of the facts, it is humbly submitted that the temple is dedicated to Thakur Sri Bange Bihari Ji and it is considered sacred by millions of devotees. The spiritual significance of Vrindavan's monument, Vrindavan as the land of Krishna's divine Leela, makes this temple not only a religious monument but also a cultural symbol of immense value. And Your Lordship, the alteration of these pradakshina routes, which is considered the most essential religious practice, has been altered without the permission or without the consultation of the devotees, Your Lordship. So their fundamental right to practice their religion is being violated and unnecessarily interfered by the state government, Your Lordship. And also, it Commissioner Hindu Religious Endowment versus Moot, 1954, SSCR 1005.
Sorry,
This
sorry
honorable
for
court
the
held.
Sorry for the interruption, but only 2 minutes you have left.
Much obliged, Your Lordship. Your Lordships, in Commission of Hindu Religious Endowment versus Shirur Moot, it was held that the matters of religion include practices that are regarded as integral to the faith. Your Lordships, it was also held in Tilak Sri Govindalji Maharaj versus State of Rajasthan. The court recognized that modes of darshan and access to the deity may form essential parts of religion. Applying these principles, the petition submits that track and allows specific entry routes and circumambulatory paths are integral to the devotional experience of Vrindavan. Your Lordship, in Adi Visheshwara of Kashi Vishwanath Temple versus State of Uttar Pradesh, the court held that state intervention in temple management must be strictly confined to secular aspects and cannot restructure matters of religion. And Your Lordship, the correct constitutional test to distinguish the faithful facilitation and unconstitutional interference has been held in Ismail Faruqi versus Union of India. In this case, the court differentiated between essential and non-essential practices, holding that the state may regulate secular aspects but cannot alter essential religious practices. Your Lordships, facilitation would mean improving lighting, sanitation, or crowd barriers that is worship without altering its manner. It is imperative that it is essential to ensure safe passages to the devotees, but it should not be done by violating the basic and integral fundamental rights of the worshippers. Your Lordship, interference occurs when the state alters ritual rules or displaces religious institutions, thereby changing the religious experience itself. The present project clearly falls in the category of interference as it restructures ritual access routes, demolishes sacred alleys, and alters the denominational management of worship. And Your Lordships, it is respectfully submitted that balancing Article 25 and 21 requires proportionality, not suppression. An unfortunate stampede has been caused. So it is essential to protect the life of the devotees as well, but it should not be at the cost of violating fundamental rights. The test of proportionality must be satisfied before moving with the project. And in a judicial precedent called TMA by Foundation versus State of Karnataka, it was emphasized that the fundamental rights must be harmonized and not destroyed. In Subramanian Swamy versus State of Tamil Nadu, it was held that restrictions on fundamental rights must be narrowly tailored. Here, the state's project sacrifices essential religious practices in the name of safety, where narrower or less restrictive options are available. Therefore, my lords, it is most respectfully submitted that the reconfiguration of temple approaches and circulation routes amounts to unconstitutional interference with religious freedom under Article 25 and denominational autonomy under Article 26. The project does not merely facilitate worship, but alters its very character, thereby violating constitutional guarantees. In conclusion, the petitioners most respectfully submit that issue 2 must be answered in their favor. The reconfiguration of temple routes is an impermissible interference with essential religious practices and denominational management. While public safety is important, it can and must be secured through lawful, proportionate, and non-intrusive alternatives. Therefore, we humbly pray that this honorable court be pleased to cash the reconfiguration of temple approaches under the Imban project. And that's all about the submission on behalf of the second issue, Your Lordship. My co-counsel will argue further.
Okay.
My Lordship, am I audible?
Yes, audible.
Lordship, myself the co-counsel. I'll be dealing with the issues 3 and 4 from the petitioner side. Lordship, may I start with my issues?
Sure.
Much obliged, my Lordship. Here, issue 3, whether the state's objectives of crowd management and public safety under Article 21 justifies large-scale demolition and redesign of an organically involved sacred present when less restrictive alternatives already exist. My Lord, here, may it please the court that the state's objective of safety, crowd management are no doubt legitimate, but they cannot justify the wholesale demolition of an organically involved sacred present under Article 21 itself is not limited to the protection of life in the narrow sense. It extends to livelihood, culture, and environment. The Vrindavana's present is not merely a physical space. It is a living cultural heritage protected by Article 49 and Article 51 AF. Demolition will displace residents, extinguish livelihoods, and erase the centuries-old cultural traditions there. As this court held in the Olga Tellus, the livelihood is an inseparable part of life, my lord, and to destroy this ecosystem is to destroy the life that thrives within it. The principle of proportionality, as crystallized in the modern dental college, requires that the state adopt the least restrictive means, my lord. Here, the burden is not met. The NDMA or National Disaster Management Authority guidelines themselves provide a safer, non-destructive measures such as staggered darshana, RFID entry, zonal holding areas, CCTV darshana, and unidirectional flows, and festival time special search plannings. These are proven across India, my lord. The Tirupati temple, Sirdhi temple, Vaishnavi Devi temple, all these models are successfully managed for large number of pilgrimage number without raising their heritage score too. The state has produced no evidence of the pilots or comparative studies showing that these alternatives are inadequate. Without exhausting such operational methods, demolition cannot satisfy the proportionality, my lord. Further, the environmental risks are really grim. The Yamuna lies within 300 to 500 meters of the site, making this present ecologically sensitive. In the Subhash Kumar case, this court held that a clean environment is integral to the life under Article 21, my lord. The massive demolition of the construction, risk of discharge, siltation, and encroachment of the floodplains, violating both the Environmental Protection Act and the Water Act of 1974. This court in the Alembic Pharmaceuticals has held that ex post facto clearance are impermissible. Yet here the state has proceeded without any prior EIA, my lord. Equally, demolition of risk and irretrievable cultural loss will be taking place here, lord. Once the traditional allies, shrines, or artifacts are destroyed, the compensation cannot restore them. The Kashi Vishwanath corridor has already shown us that how the idols and heritage items were lost within the process. This doctrine of precaution, constitutionalized in the Vellore State and Welfare Forum, requires that where less risky alternatives already exist, then irreversible demolition in a fragile heritage zone cannot be the state's first option. Lastly, the decision reflects arbitrariness prohibited under Article 14 as per EP Royapa by overlooking less disruptive measures and bypassing the statutory safeguards. The state's action is not only disproportionate but manifestly arbitrary. Therefore, we respectfully submit that this honorable court should stay demolition and acquisition. Instead, direct adoption of NDMA compliant, non-destructive crowd management measures alongside of completion of statutory clearances and public consultations. Such relief preserves both the safety and the heritage, aligning with the proportionality under Article 21. My lord, if my lord is well versed with the issue 3, may the council move to the issue 4, my lord?
Yes. Please.
Much obliged, my lord. Issue 4 is whether the absence of inadequacy of a meaningful public consultation renders the decision-making process arbitrary under Article 14. May it please the court that the Article 14 strikes the arbitrariness, and this court in EP Royapa declared that the arbitrariness and equality are sworn enemies. The state's decision to redesign and demolish the sacred prison without meaningful consultation is the very definition of the arbitrariness. The projects that displaces family, alters heritage, affects ecology cannot be imposed unilaterally, my lord. In the Banvasa Sevasram, this court held that displacement of vulnerable communities require fair treatment and participatory safeguards. Likewise, in the Bangalore Medical Trust, and the arbitrary conversion of a park into a private hospital was struck down for the excluding community interest. These precedents establish that the exclusion of stakeholders in projects of the public impact violates the equality mandate. Further consultation is not a matter of grace. It is constitutional necessity in Maneka Gandhi that this court expanded Article 14 to encompass fairness to procedure. Public hearing embody that fairness by giving affected persons a chance to hear and participate. Its absence renders that the process is unreasonable and unconstitutional. This is reinforced by the statutory schemes. The EIA or Environmental Impact Assessment notification of 2006 mandates the public hearing before the clearances of a project with significant environmental impact. In the Alembic Pharmaceuticals, this court held that the safeguards under the EIA process are not an empty formalities, and approval in the violation of these procedures are legally unsustainable, my lord. Here, no such consultations or no clearances has taken place. Similarly, in the RFCT LARR, Right for Compensation, Transparency, Land Acquisition Act of 2013, explicitly requires social impact assessments and public hearing before land acquisitions. In the Union of India versus Shivaraj, the non-compliance with these provisions was held to invalidate the accusation itself. The state's failure to undertake these safeguards deny residents to their statutory and constitutional rights. The heritage laws also demand the consultation. Finally, the principle of natural justice, which is odi alteram partem, my lord, requires that those affected must be heard. The court in the AK Karpak made clear that even administration actions must comply with fairness. The residents, shopkeepers, and religious bodies in the Vrindavan who are directly affected were never consulted. This compounded arbitrariness with the denial of natural justice, in some, the absence of meaningful consultation renders the process constitutionally infirm under Article 14, statutory defective under EIA and land acquisition law, and violative of natural justice. We respectfully pray that this honorable court hold that no irreversible work proceeds under proper statutory consultations, public hearing, and impact assessments are completed. My lord, if my lord is satisfied with the issues, may the council move to the prayers.
Yes, please.
Much obliged, my lord. Therefore, in the lights of facts stated, arguments advanced, and authorities cited, the petitioner respectfully prays that this honorable court may quash and set aside the judgment of mandamus of Allahabad High Court in writ petition 2. The Bangi Bihari Temple Corridor project in its current form violates the petitioner's fundamental rights under Article 14, 19(1)G, 21, 25, 26, and 308. Hold that the respondent state act arbitrarily failing to comply with statutory safeguard under the LARR Act of 2013, Environmental Protection Act in 1986, Water Act in 1974, and AMASR Act of 1958, and direct suspension of all the project activities until the compliance. 4. Mandate the exploration of heritage sensitive and less restrictive alternatives from crowd management and safety. Constitute an independent court supervision community of experts and stakeholders to review the project and recommend proportionate sustainable measures. Pass any further order necessary to protect constitutional right and ensure for this act of kindness the petitioner shall duty bound forever pray. It is indeed an honor to present this case before this honorable court. Satyameva Jayate.
Yes, Mr. Respondent.
Your Lordship, am I audible?
Yes, audible.
The respondent's counsel seek.
Mr. Respondent, your voice is not respondent. You are not audible.
Sir, can you hear me?
Yeah, sure. Yes, I hear you. Yeah, please.
Shall I proceed?
Yes, you proceed.
Okay, I'm proceeding with the formalities. The respondent's counsel.
First of all, tell me
yes, Lordship.
your name, please. Who's your representative?
Your Lordship, I'm the representative.
Yes. Okay. Yes, yes, I can hear you.
You can hear me, Your Lordship?
Yes, yes, please continue.
Your Lordship, with your permission.
Yes.
Firstly, Your Lordship, seeking the permission of the court, the respondent's counsel seeks the permission to approach the dais to present the views.
Yes, please.
Also seeking permission to collectively approach the bench as Your Lordship.
Come again? Sorry.
Also seeking permission to collectively address the bench as Your Lordship.
Yes, please.
Much obliged, Your Lordship. Lordship, as you are well acquainted with the matters and the facts of the case, shall I go ahead with the issues and the respondent's answer to those particular matters?
Yes, please.
Much obliged, Your Lordship. Firstly, I'll be reading out the first issue just for the sake of better understanding, and then I'll be speaking on myself and not reading anything. With your permission, Your Lordship, going ahead. Whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy or is a constitutional valid exercise to remedy systematic failure endangering life and safety. Your Lordship, I'll be handling this matter completely on aspects of logic, because and the council and the respondent, their team, they personally believe that logic is something that grounds law to its very foundation and its very roots. Now, what is the very aspect at first place? We have a scenario where there is a religious temple, and that religious temple has a huge amount of rush, which is making it a very problematic place where in the recent Janmashtami, quite a few number of people have died. Now, we have to take into consideration a very important aspect, that it cannot be the state's fault completely, because the concerned region, the place of destination, is also a party to this particular case. It is not that we can call or this country or this given memorial states given precedences where such traffic-based issues have taken place across the state of Uttar Pradesh. By we haven't been furnished with that, so we can assume that the given party, the even the religious authority, it has a role to play in this given thing. Now, people have died, and the state has taken an initiative to create a corridor which is in the lines of something which has a judicial precedence, that being the Kashi Vishwanath corridor. Talking about that corridor, I'll come back to it again as well. That being the amount of money spent in the Kashi Vishwanath corridor, the overall expenditure came down to 800 crores, because I know that 300 crores will come back to bite me. So I'm just mentioning it beforehand with your permission, Your Lordship. Now the state has taken this initiative of creating a innovative infrastructure where we are not completely displacing the livelihoods of people. Once the corridor is completely conceived, people will get their places, things will be better approachable, and from the aspects of business and from the aspects of law, where approachability leads to better business, we can also assume that in the forthcoming, people who agree to this given plan, it will lead to them also making more money in the time to come. From the aspects of property, going by the precedence which is applicable in every city in this country, be it tier 2, tier 3, tier 4, that being that a major infrastructural or civil development taking place in your neighborhood always drives the price of the property up. So, in the respondents team, there is a fear that the petitioner are creating all this ruckus for better compensation or for better extraction from the state regarding this entire affair. Now, this entire thing is a completely civil infrastructural project which has its own backing, own research, and already, as the case states, that we have already spent 300 crores. Now, spending of 300 crores in a given project does not mean that we are spending it only for buying a cement or only for the buying of infrastructural or steel rods or things like that. It can also mean that we are probably availing the advice of some of the best civil consultancies in the world and making this a proper long lasting infrastructural creation. So on that ground, Article 21 of the Indian Constitution clearly states that beyond everything, if there is no life, there is no state at first place. So, if the state is taking an initiative, spending money which it has found through the exchequer and through the people for the betterment of the people and for their better lives, how come the state is wrong and how come aspects of 32 is applicable? I do not understand, Your Lordship. Maybe the court can enlighten me. It is my understanding of this given matter. So, regarding the constitutional validity of this given matter, while taking into consideration at least Article 21, because a country, a constitution can only come into place when there is a state, and a state can come into place when there are citizens, and a citizens can only be applicable when they're alive. So,
Yes,
moving into Article 21, which is important for them being alive, this is a very important initiative being taken by the state for them being alive. This is a long lasting project. Maybe it will create issues for the time being, very much like a flyover being created in the neighborhood. one may, but in the long term, or a metro station which is coming to one's neighborhood. So initially it might have some traffic issues, but the long time repercussions of this given matter will be for the benefit of the people of the state at first place. With
Okay.
Lordship, if I have satisfied issue number one, with your permission, can I move to issue
Yes,
number two?
I'm satisfied.
Again,
Please continue.
I'll not be reading out from the matter, and I'll be speaking out from what I've understood from my heart regarding article number 25 and 26, which
Yes, sir.
talks about the freedom of practice and the freedom to manage religious affairs. Now, when it comes to the freedom of practice, I like to state, as a Hindu, this is a Hindu religious place, and I like to quote the Rig Veda itself, which I have read. I'm very sure my fellow councils have also read, where it states that circumnavigating of a religious place is very important. That is a very important, because the foundations of Hinduism, if we can get into, because this being a matter of religious affair, if I
Sorry
can
for the
get into,
interruption. For respondent side, you have only 2 minutes for the speaker one.
thank you, much obliged. If I may continue, your lordship.
Yes, continue.
Your lordship, so the aspects of Hinduism has evolved over time, over 5,000, 10,000 years, because of anthropological reasons, where not every aspect of that religion may be essential for the fulfillment of the basic duty of faith towards God. Now,
Okay.
going by that particular aspect, we do not think that this temporary civil intervention in making a religious place far more admissible and far more prayable for people, and very much, as I quoted your lordship, with your permission, the aspect of the flyover, that the present scenario may seem problematic, but the long term effects of this thing will be a very positive effect. Moving to aspects of 26, Article 26, which talks about religious interference, your lordship, where people have died, hundreds of people have died. Your lordship, with your court's permission, if I may ask this thing, like, isn't it the court, within the authority of the court, to intervene when a religious authority is not being able to manage with the state, where the religious authority is also in a role? It has 50 lakh visitors. The state is not having 50 lakh visitors in one of its tourist places. It is having 50 lakh visitors because of the religious place at first place. So it is also a party to the scenario. So it cannot say that I was not a party to that mishap which happened on Janmashtami Mangala Aarti, where so many people died. So the institution is at fault, and if the state is making some intervention, it's not a coup d'etat where the state is taking all the powers away from the concerned mahants. It is making some intervention which might uplift the real estate valuation of that given place at the same time. So I don't think the state is at fault in any way, your lordship. It was a complete presentation presented on grounds of logic and stuck to the questions. And if any queries, I may answer, your lordship.
No, it's okay. And please continue.
Much obliged, your lordship. The remaining queries would be handled by my fellow counsel, your lordship. The queries number 3 and 4. With your permission, lordship, may I shut the camera off so that he can focus well?
Yes, sure. 100%.
Much obliged, your lordship.
Your lordship, as my fellow co-counsel has stated, issue 1 and issue 2, I will move forward to issue 3 and issue with your permission, your lordship.
Yes, please continue.
Much obliged, your lordship. Your lordship, as issue 3 and issue 4 says that the compensation and rehabilitation rights displaced residents do not obligate state to halt essential corridor project. Your lordship, I would like to cite to your cite to your attention that the Land Acquisition Act mandates a comprehensive framework for land acquisition and rehabilitation, so requiring fair compensation, adequate settlement, consultation, and participation of affected person, with procedural safeguards to minimize hardships and ensure livelihood restoration. So failure to comply may vitiate the acquisition process. So your lordship, in this case, in this case, application to the facts of the Banke Bihari corridor project. The Banke Bihari temple corridor project involves acquisition of land and displacement of a limited number of local residents and small business around the temple due to the necessity of widening lanes, creating safe passages, and handling pilgrim infects safety. The businesses are shifted. Now, Your Lordship, the respondents acknowledge the hardships imposed by the displacement, but submits that the state has complied or is committed to complying with all relevant legal mandates, including those under the Land Acquisition Act, for ensuring fair compensation, resettlement allowances, and consultation procedures with affected person. The alternative, or halting or indefinitely delaying the project will lead the project pending complete resolution of all displacement issues, and which is neither feasible or nor in the public interest, Your Lordship. As my fellow co-counsel has already stated you the facts of that, if we delay the project, it will lead to a delay in the whole effect, because if in the next Janmashtami, if the people or if the pilgrimage comes, if again the same stampede occurs, then lots of life will be in at stake. So after investing in a project and then it delaying the project will help it will means is neither feasible and not in the safe for the public, because it can lead to the risk to life and safety posed by the current congested infrastructure, and which is why the current Banke Bihari project corridor is necessitates the urgent action. Your Lordship, if I come to the right to livelihood under Article 21, which says that the state's obligation to protect the lives of millions of pilgrims and residents. And as my fellow co-counsel has already stated you the fact that if the lives are not saved, then what will be it is the duty for the people first to save the life under Article 21. So a holistic view of competing constitutional mandates favor the continuation of the corridor project with due care to fair and just compensation process rather than halting critical public safety infrastructure. Your Lordship, the minimizing displacement through design adjustment consultation aligns with the constitutional ethos as well, but does not grant displaced individuals veto power over essential public projects when fair rehabilitation processes are followed. Now, coming to the aspect that displacement and compensation issues do not bar lawful execution of the project, the respondent respectfully submits that while the rights of the displaced residents and small businesses under Article 21 and 300A, as my counsels of the petitioner has stated that under Article 21 and 300, the statutory framework deserve full respect, recognition, and remedy. These concerns do not justify restraining or restalling the Banke Bihari Temple Corridor project at the first stake, Your Lordship. Your Lordship, the state is lawfully exercising its power for a matter of paramount public interest, protecting life, and ensuring safer religious worship. Your Lordship, Your Lordship, the state also uh, doing adequate compensation and rehabilitation constitute appropriate, leading to the constitution mandated remedies rather than impediments to public welfare. And I urge you to the court to uphold the corridors project continuation while directing the state to ensure compliance with all compensation, resettlement, and rehabilitation obligations as per with collective welfare of the welfare under the constitution. If you, with your due permission, Your Lordship, can I move to the issue 4?
Just a second. Yes, please.
Much obliged, Your Lordship. Your Lordship, as issue 4 says about the Article 14, an environmental clearance and procedure which does not comply with Article 14, and the no arbitrariness or unreasonable discrimination, as my fellow counsels of the petitioner has stated. So, if I come into the fact of Article 14, so Article 14 of the Constitution of India mandates that the state shall not deny to any person equality. State shall deny every person equality under the law. So now this provision embodies the fundamental guarantee of equality and prohibits the state from engaging in arbitrary or discriminatory acts. So now the courts have articulated two pronged test under Article 14 to evaluate state actions involving classification. The classification must be based on an intelligible differentia that distinguish the persons or things group from others left out of the group, and the differentia must bear a rational nexus to the objects sought to be achieved by the legislation of state actions. If taken under the case law of Ramakrishna Dalmia versus Justice S.R. Tendulkar, reaffirm this arbitrary classification or class legislation So moving to the fact of concept of equality, Your Lordship, the concept of equality under Article 40 is not absolute sameness but equitable treatment. Now, allowing reasonable classification based on relevant distinction and objectives. Where the state action involves environmental governance, as my fellow co-counsels of the petitioner has already stated, the Article 14 demands fair, non-arbitrary procedures, including environmental assessment and clearings, and avoiding discriminatory or any other treatment that is similarly situated to the leading to the project's inequality or to the persons who have been unequalized. In this case, if I talk about Article 14. Now, coming to the aspect of the Banke Bihari Corridor project, the Banke Bihari Corridor project environmental clearances and impact and comply fully with Article 14, following a transparent, reasoned, and non-arbitrary process consistent with environmental statutes and constitutional mandates. Because the state has applied uniform environmental standards and procedures, engaging in stakeholder consultations, reflecting equitable treatment of affected groups and public interest, applying consistent environmental norms in ecologically sensitive zones near the Yamuna River comparable to other regulated projects, and no evidence exists of arbitrary classification or discriminatory treatment or procedural unfairness in clearing or supervising the project's environmental aspects. Now, the rejection of any unsubstantiated allegations that the project lacks adequate clearance or that environmental procedures
So,
have been
Mr.
circumvented affirms compliance with the constitutional mandate of equitable and non-arbitrary. Yes,
Mr.
Your Lordship.
Counsel, you are not proper
Hello.
audible.
Yes, Your Lordship.
Yes, yes, yes.
Am I audible? Am I audible?
Yes,
Much obliged,
yes.
Your Lordship. Yes, Your Lordship. So, stating the fact that no evidence exists of arbitrary classification and the rejection of unsubstantiated allegations that the project lacks adequate clearance or that environmental procedures have been circumvented affirms compliance with the constitutional mandate of equitable and non-arbitrary state action. So, by carefully balancing environmental protection with the pressing need to safeguard public safety and heritage through regulated development, the state approach reflects mature constitutional governance consonant with Article 14. Your Lordship, where multiple competing interests arise, heritage conservation, environmental sustainability, public safety, and religious freedom, the state's reason and procedurally fair classification of interests and regulatory response is constitutionally valid. Your Lordship, with that, the respondents respectfully submits that the state's environmental clearances process for the Banke Bihari Temple Corridor project complies with Article 14 and with reasonable classification, non-arbitrariness. Yes, Your Lordship.
Continue.
Yeah, the project's adherence to statutory yes, Your Lordship. The project adherence to statutory procedures, uniform application of environmental standards, and incorporation of mitigation measures satisfy the guarantees of equality before law and equal protection of the law. So the court should uphold the procedural and substantive environmental clearance as constitutionally valid, ensuring that development imperatives harmonize with environmental protection under a regime of fairness and reason. With your due permission, Your Lordship, may I move to the prayer?
Yes. Yes,
Much
yes,
obliged,
please.
Your Lordship. Moving to the prayer, wherever in the lights of the issue raised, arguments advanced, and authorities cited, it is humbly prayed to this honorable court that uphold and affirm the impunged judgments and orders of the Allahabad High Court directing in the execution of the Banke Bihari Corridor Temple project as a constitutionally valid exercise of the judicial power under the Constitution of India. Declared that the reconfiguration and redevelopment of the temple and adjoining alleys pursuant to the corridor project constitute a reasonable and permissible regulation of religious freedom under Article 25 and 26 of the Constitution. Affirm that displacement and acquisition arising from the project comply with Article 21 as well as 300A and as well as the right to fair compensation, transparency in land acquisition, rehabilitation and resettlement act, and direct the continuation of the project with due adherence to fair and just compensation, and recognize that environmental clearance undertaken for the project adhere to the constitutional mandates under Article 21 and statutory requirements under the Environmental Protection Act, and dismiss all petitions and challenges impeding the progress of the Banke Bihari Temple Corridor project in the interest of the safeguarding public safety, protecting fundamental rights, and ensuring the continuous religious and cultural heritage of Vrindavan while guaranteeing effective and fair mechanisms for environmental protection and rehabilitation of displaced persons, and pass any other order, direction, or belief that it may deem fit in the interest of justice, fairness, equity, and good conscience. With the council's respondent, I rest my case. Much obliged, Your Lordship.
Very good to hear all the councils. First of all, I just congratulations to all. First of all, to be here and just saying something to represent your case in front of me as a judge. You all are good, but first of all, I move to the petitioner. Petitioner number 1, who is representing this case. First of all, I'm saying that you are just come in a court, and reality, just you face the judges. It's an eye to eye contact, not the readable documents you are going to. Just petition number 1, I'm just saying you are well good. And petition number 2. Petition number 2.
Thank you, sir.
Just gave you a suggestion. When you see the when you represent your case, first of all, you just read your overall petition in your mind and face the judges. Don't read in front of him, because there is a dimension here, and there is not a concept of book you are just read in front of the judges. Well prepared. Just I am not saying that you are not prepared. You are well prepared, but you just concentrate on the eye contact. When you give the representative reality in front of the court, you just acknowledge the same what you have learned, and well prepared for the rest of the case. Just move on towards the respondent. Respondent is, I'm just clap for you, because your representative is well prepared, well knowledgeable.
Much obliged, Your Lordship. Much obliged.
Both of them are very good. And just I review this, and we will keep you on, and we will give you the best of the best for you coming in a reality of court. Okay, and all the best for the future. And petitioner,
Your Lordship.
Petitioner, don't mind it. It's just your beginning. Just you represent before me as in a moot court, and we will forward you and looking to be better in the reality of court. Okay, that's all I'm saying, and I'll give you the overall reviews. And please don't see this. We will share you the remarks, and you just see your remarks, and you will be guided by the remarks. You will better than this in future. That's all I can say. All the best. Thank you so much.
Thank you.
Much obliged, Your Lordship. Means a lot, Your Lordship.
Thank you, Lordship, for your valuable feedback to the councils. Now I request all the participants to kindly leave the meeting room, and would request to Mr. Honorable Judge to please stay in the courtroom.
Much
Thank you,
obliged, Your Lordship, and it was an honor to participate with the fellow participants.